Hello, everyone. I extend my warmest welcome to everyone invited here on this online platform on this very auspicious moment. Today's webinar is hosted by Center for International Alternative Dispute Resolution, CIADr. And today's topic is benefits and challenges of institutional ADR mechanisms. First, I would like to say a thing or two about CIADr. CIADr is the first and only online dispute resolution center in Bangladesh, which provides reliable and cost-effective dispute resolution services since 2018. Within a span of only 2 years, CIADr has established itself as a benchmark of online dispute resolution services. In this new era of ODR development and expansion, CIADr is an uninterrupted provider of premium institutional aid for conducting domestic and international ADR and ODR proceedings. CIADr has become a brand name in South Asia for its well-experienced independent arbitrators, mediators, as well as for its fast rating and cost-efficient dispute resolution services. As part of CIADr's public awareness activity, it has introduced the concept of webinar series to make the basics of ADR and ODR accessible to mass people. CIADr webinar series is paving a path to create an actionable community in order to combat the future economic crisis in the global community. Today's webinar is designed to cover one of the vital issues, that is, benefits and challenges of institutional ADR mechanisms. This webinar is divided into two parts. At the beginning, our keynote speaker, Dr. Kabir and Rekha Rangachari, will deliver their presentation regarding the benefits and challenges of institutional ADR mechanisms. At the end of their speech, there will be a question answering session. Throughout this webinar, I'll be your moderator. First, I would like to say a few words about myself. I'm Ahmed Raquib Malik. I'm a barrister-at-law of the Honorable Society of Lincoln's Inn. I have completed my LLB at the University of London and did my PGDL in Bar Professional Training course from the Northumbria University, Newcastle. I was called to the Bar of England and Wales from the Honorable Society of Lincoln's Inn on 8th of March 2018. After coming back to Bangladesh, I have been working as an associate at law firms, namely Malik & Associates and Karim & Karim Associates. My core responsibility is conducting legal research, drafting petitions, preparing legal documents, client handling, and assisting clients out of court settlement. I was actively engaged in few arbitration and mediation sessions concerning family disputes, matters related to money loan, and contractual disputes with active arbitration clauses. In the span of last 2 years, I have witnessed how a well-experienced arbitrator or a mediator can resolve a dispute by ensuring the party autonomy and flexibility, which eventually helps the parties to save both time and money. As we all know, the COVID-19 pandemic has brought the world to a standstill, which adversely affected almost every sector of this global economy. In the post-pandemic era, there will be indefinite number of cases, and the judiciary might face the highest challenge of the century in the post-pandemic era. Therefore, ADR could be used as a significant tool to alleviate the burden on the judiciary by reducing the number of urgent cases, which would help them to function normally. Many lawyers, academics, young practitioners, jurists, and judges are working together to create a global framework for ADR and ODR proceedings in order to deal with the post-COVID-19 challenges. Therefore, it is imperative to have a written guideline and established practice to ensure neutral, independent, and impartial ADR proceedings. At this point, I will give you a brief introduction of our keynote speakers, Many of you already know them by name. They are none other than Dr. Kabir, Duggal, and Rekha Rangachari. Dr. Kabir is an attorney in the New York office of the law firm, namely Arnold and Porter. His practice focuses on international investment arbitration, international commercial arbitration, and public international law. He has served both as a counsel and as an arbitrator. He is a lecturer in law at Columbia Law School, where he teaches international investment law and arbitration, and is a course director and faculty member for Columbia Law School's Chartered Institute of Arbitrators comprehensive course on international arbitration. Our another keynote speaker, Rekha, is the executive director of the New York International Arbitration Center and helps to shape arbitration and dispute resolution practices from her platform in New York on various bar associations, councils, and committees. Let me tell you something about New York International Arbitration Center, NYIAC. It is an independent, not-for-profit organization focused on providing hearing center services for international arbitrations, mediations, and other forms of alternative dispute resolution under any arbitration rules. NYIAC does not administer hearings, but provides hearing rooms, breakout rooms, neutral areas, and on-site support for dispute resolution cases. In addition, NYIAC organizes educational events and focuses on advancing and promoting international arbitration in New York by inviting practitioners to be involved. The center was established following the recommendation by a task force of the New York State Bar Association, NYSBA, in 2011. According to NYIAC's chair, Judith Kay, the former chief judge of the state of New York, who stated, and I quote, "With the opening of NYIAC, New York now has a world-class hearing center and hub for the city's thriving international arbitration community." Rekha chairs the arbitration subcommittee of the New York City Bar's Inter-American Affairs Committee and co-chairs the private international law interest group with Dr. Kabir at the American Society of International Law. Rekha is also the board member of the Association for Conflict Resolution of Greater New York and the New York Coalition of Women's Initiatives. And she's an associate editor of the Juris Investment Arbitration Conference volumes and adjunct professor at Seton Hall Law School. One of the interesting facts is both of our keynote speakers are multi-talented persons in real life. Since prior to law, Rekha was a Bharatanatyam dancer touring with Natta Dance Theatre, and Dr. Kabir can do yoga headstand. You may ask him to show you when you meet next. Now for all sorts of viewers, I'm going to say briefly about what is institutional ADR. An institutional ADR is one in which a specialized institution intervenes and takes on the role of administering the ADR process. Each institution has its own set of rules which provide a framework for the ADR and its own form of administration to assist in the process. Some of the advantages of the institutional ADR process are the availability of pre-established rules and procedures, which ensures the ADR proceedings begin in a timely manner, the administrative assistance from the institution, which will provide a secretariat or court of arbitration, a list of qualified arbitrators to choose from, assistance in encouraging reluctant parties to proceed with the ADR, and it's an established format with a proven record. Now, it's time to get some deeper insights from our expert guests for this episode. Just a little housekeeping before we get started. If you have any sort of queries during the presentation, please type them into the Facebook Live comment section or any other method. I'll bring them up during the presentation, and we will also have a time for the question answering at the end. I'll now hand over to Dr. Kabir and Rekha, the iconic arbitrators, to deliver their speech. Dr. Kabir and Rekha, the red carpet is rolled out for you. Thank you.
Thank you very much. I think we're both delighted to be here. I really wish we could be there in person with all of you, but this is very relevant to what we're going to be talking about, because the issue you raised is institutional arbitration. In light of the pandemic, in light of COVID-19, right? Institutions globally are trying to adjust how they administer cases. And suddenly, the reality of having a hearing virtually has become possible. And we thought it would be a good idea for us to speak a little bit about that, just because I think it'll be timely. Give me 1 second. Let's just get back to our first slide. And I will pass the floor actually to the amazing Professor Rekha Rangachari to start the discussion and walk us through some of the issues.
Sure. Well, first and foremost, as Kabir has already said, it's a pleasure. We would much rather love to be with you in person, but we hope that soon we'll be able to do that again. And we hope that you all are staying safe and healthy where you are. Thanks for joining us. Also, our thanks to CIADr and specifically to Abdullah, who has been artful in walking us through this and building us up to today, as well as our artful moderator. As you all know, pandemic in general has taught us that we have to be able to respond to necessary disruption. What does that mean? What is the way that ADR can be resilient? And, it's really in this field of law that I think we've seen the most progress, and necessarily so, as we adapt. So Kabir and I think in general are going not only from to talk about international arbitration and mediation in general, acknowledging that there are two systems at play within this, if not more, where you can lend yourself to an institution to help oversee the process and the benefits that lie therein, or when you go ad hoc, and what are concerns. In general, the sort of concerns we're going to talk about are things that are global across regardless. And so, if we go to the next slide, these are just some things that that we can begin to think about. Why is it important in pandemic that we need to start thinking about this? These are the issues. And Kabir is going to walk us through each of these. But this is why, most importantly, we've had to adapt. We've had to be resilient, because in truth, our ADR mechanisms were getting a lot of criticism that they weren't actually doing all of the benefits that we set out when we tried to demonstrate how we were different and better even than litigation. So Kabir, what are some of the cruxes of our system pre-COVID?
Thank you, Rekha. Rekha and I always joke about this, that there was arbitration BC, right? And you may be thinking that we're talking about BC in a very temporal sense. But when we say BC, we mean before COVID. So we're really talking about how was arbitration conducted like 3 months ago, right? And 4 features generally tended to stand up, right? Arbitration, and this is globally true. Arbitration involved a fair amount of paper, right? You exchanged your memorials, you exchanged document production pieces of paper, you exchanged pre-hearing briefs, you exchanged post-hearing briefs. All of this was fairly paper-driven. And then at least in international arbitrations, right, there was a lot of travel, right? Now, we highly appreciate and commend what CIADr is doing, because y'all are creating, I think, a very nice forum within Bangladesh. And really, the institution is developing a regional focus So we highly commend that. One of the realities, though, in international arbitration was, we tended to fly. Now, let's imagine there was a dispute involving a Bangladeshi party and, say, a party from France. The counsel is from UK, somebody very smart like our moderator who studied there. And we had somebody from the US. The hearing's going to take place, say, in Dubai. Now, if you look at the number of cities involved, everyone had to get together in one room in Dubai. Everybody's flying. There was just a lot of travel, right?
Yes.
Just related to that, we had motion practice, right? You challenge the arbitrator. You're seeking interim relief. You're seeking emergency relief. All this led to a lot of motion practice. And this led generally to the process getting drawn out, right? Now, look, we're seeing a lot of advantages for arbitration, and we don't want to undermine any of those advantages. But this time and delay does have a heavy toll, especially on the client. Now, this was the reality. This is how we did things. What has changed with COVID? Rekha, perhaps you want to walk us through that and tell us, how has COVID changed the reality? What are some of the changes we are seeing, and how are things going forward?
Sure. Well, so, when we talk about now in COVID, right, we're sort of talking about how we've had to all go virtual, much like we're doing on this webinar, that we can talk amongst ourselves. And although we've always been able to do that, right, actually embracing the technology to do it on a regular basis perhaps wasn't the norm. I think many of us are experiencing, whether it's webinar jam fatigue or Zoom fatigue or WebEx fatigue, insert your platform, and there's definitively a fatigue of it, because in adapting so readily, now we no longer just have a telephone call with a colleague, regardless of which jurisdiction they sit in, but rather, let's hop on in video, let's have the human connection. As we think in general about how we've shifted into virtual setups, there are key concerns and considerations we're going to go through. We'll underscore that institutions have really been at the forefront to show us what to do as we adapt into virtual. And there's a whole host of resources each institution has put out that we're happy to share with you, either through the portal or after this program. But each one has demonstrated that they're really guiding the force, laying out foundations and procedural orders, forcing us to think critically about security and safety, end-to-end encryption, as well as items like, what are top concerns for the arbitrator, for counsel, for witnesses? Is it really possible to achieve comprehensive proceedings where there aren't due process concerns? And so think about this as we talk through. In general, what we're seeing for virtual proceedings and online dispute resolution as a whole is where courts across the world were closing. How do you get access to justice? Indeed, ADR demonstrated its resilience by remaining open and available. And even more so, many arbitral institutions adapted their rules prior to COVID to include aspects like emergency relief, interim relief, expedited arbitration. These were all items that we talked a lot about at academic conferences, but to query how often they were being used. In COVID times, there was an uptick in use of any of these mechanisms. And so a credit to the institutions for knowing long before we even got here that there may come a time when we would really need to use them. While courts were closed, access to justice in general, because the court logs, although courts in some jurisdictions are opening, they're taking cases virtually, much like institutions are, there's still quite a backlog, right? And then as Kabir mentioned, where we're hopping around the world in different jurisdictions contingent on where clients are based, counsel are based, the seat of the arbitration is, we're dealing necessarily with time zone. There's no optimal time zone. And in truth, even as we've gone to virtual, somebody has had to compromise so that when you run a 2-week hearing, you're able to run it efficiently. So geographic issues, cost issues overall, we're not dealing with travel as much. I think in general, many of us are thinking also our business development spends as we would travel around the world, speaking and engaging at conferences with colleagues? Can we do more things virtual now? You'll see last week, Paris Arbitration Week went virtual as well. The UNCITRAL general sessions went virtual. So we're demonstrating that we're able to do it, and we're still able to also network in virtual. So think about the logistic realities, things that we always held out as tenets of arbitration and mediation. But as things developed, as counsel developed, the pleadings developed, the paper developed, we cut against these key tenets: efficiency, flexibility, accessibility. And if one good comes out of COVID, it's that we've been able to hold these tenets up again and really think about them in real time and achieving them. With that, Kabir, I'll give you back the floor.
Thank you. Thank you very much, Rekha. That's fascinating. Rekha, you have also managed hundreds of cases, both in your present position and your past position. How do you see ODR? Do you see it as a positive development? Do you see it as something we're going to do more and more of? How do you see ODR? I know you passed the floor back to me, but I really think we will benefit from your expertise.
So I appreciate. Thanks so much. I'll let the audience know. So prior to becoming director of NIAC being a venue for big arbitrations and mediations, I worked at the AAA ICDR, American Arbitration Association, International Center for Dispute Resolution, as case counsel in both of those parts. And so I think in general, where we were seeing issues, even there where witnesses, for example, couldn't come to the hearing for any number of reasons, that we were using video conferencing for some testimony, but rarely were we taking full proceedings virtual for many reasons, due process as one example underscoring why we got together in person. I think in pandemic, for us to really think critically about how we can structure proceedings to be more efficient, I would argue to you that they've become more efficient indeed, because we can't sit in virtual as long as we could with breaks in person. And so I think that's a key benefit. But in general, how can we adapt to handle our proceedings and move them forward without delaying the timelines to wait until it's safe to meet in person again? So I do think we're really revolutionizing. A testament is, if you ask many of the leading arbitral institutions, including the AAA ICDR, e-filings are up. So in spite of all of this, and I think as our adept moderator hinted to, we're certainly, as we look to the future, more disputes are only going to come as we talk about disruption of business, even as we deal with claims of force majeure, the relevance of force majeure certificates. We're seeing some jurisdictions issue. In total, business stopped, much like our personal and professional lives have sort of been in pause. And so what does that mean? How do we resurrect? How do we deal with damages, continuation of projects, impossibility, and the like? And I think the institutions are necessarily going to be on hand to deal with that. And especially when courts were closed, how are we dealing with other issues, much like those expedited and interim relief measures, which are critical if you're worried about dissipation of assets, while proceedings are running. So I really need to credit first the institutions for showing us how to do it. But indeed, I think ODR is a very important benefit of where we're headed. In truth, will we stay in virtual as we go forward and emerge from our shelter in places? Time will only tell. But I think at best, we're certainly headed towards hybrid arbitration hearings where we can use that efficiency. What does hybrid mean? Arguably, no one counsel will agree that the other counsel gets to be present with the tribunal if there's some issue of travel where only one counsel can be present. So I think we're going to have to weigh due process concerns and access against what makes the process more efficient if we all don't have to sit together.
Thank you.
But you know what, Kabir, to be fair, let's also turn it back to you. So Kabir and I also are good friends, so we like to hand the mic back and forth because we also think that's more interesting. But from a
definitely. Yeah.
From a practitioner's perspective, I gave sort of the high overview from an institutional perspective and from what I've seen. as a hearing venue at NIAC. I don't know when we'll go back. We're following the orders closely in New York. But when in a mindset will it be safe for us to gather? That's quite a different thing. And that's perception as well. But for you as a practitioner, working on both commercial and investor state cases, what are you seeing in your practice?
Thank you, Rekha. I think my reaction is similar to yours, right? I think we're seeing a greater willingness, we're seeing a greater acceptance for ODR than we ever have. 3 months ago, the idea that we could have an event jointly over a web platform with folks in Dhaka on one side, New York in one side, was something we couldn't envision. Now we're seeing realities like this happening in such an effective manner.
Yes,
right?
indeed.
The platform is so seamless. And we see the same thing for hearings. We see this willingness to talk, the willingness to engage in a much more real way. Having said that, I think the point you make, would you be able to do a multi-billion-dollar dispute with 15 experts and 20 witnesses with parties from Australia, let's say Bangladesh, and New York at any given time zone virtually? Remains to be seen. Right?
I think with that too, and you were going to mention this probably, the translation issues alone of what is our key modicum of engagement. I don't know how you achieve multilingual with one language of translation seems feasible, but many more. Right. I think we're running into some major issues.
Correct. And actually, I think this takes us very nicely into the next area we were planning to talk about. Like, we're seeing this greater willingness, this greater engagement, this very positive reality. But what are some of the challenges if you're going to have hearings virtually? If you're going to move to an online model, right? What are some of the challenges? And some concerns that we see, and this is something we should all think about, because these are going to be challenges for all of us, right? And see, one concern is, how do you prevent in a virtual setup witness coaching? Now, right now, I can see the three of you, right? I see your faces. I see what's behind you. I don't see what's in front of you. Now, if you're having a cross-examination of a witness, and let's assume the worst case situation, somebody's sitting in the front with prompts and giving you answers. How do we adjust that? Now, institutions are coming up with solutions, right? You're not allowed to use virtual screens. I know you and I will be talking about that further, but this is something we should be talking about. And then the other issue, if you're going to do things virtually, you need to have internet. You need to have facilities that your internet can work effectively. Now, somehow, and this is very entertaining and amusing for me, somehow we move on the presumption, and it's a totally false presumption, that if you're from the developing world, the internet's going to be bad. If you're from the developed world, the internet's going to be good. And it's always amusing for me to see this turn out false on its face. Just to share an example, we had a webinar. I'm hosting this webinar series again with NIAC being one of the co-sponsors. And we've had speakers from South Asia. We've had speakers from Africa. No problem with the internet. And then you have a speaker from France and the internet drops. But this is the reality, right? Virtual things work effectively when you have good technology. And you need to have technology that you're familiar with. Now, the platform we're using today, Webinar Jam, is a very intuitive, in my view, a very sophisticated platform. There are features here that, I feel like a little bit of a kid in a toy store. I want to play with everything. But it's a very intuitive platform. It requires, generally, these platforms require you to spend some time getting used to them. Today, Rekha, you and I are very familiar with what has become popular, at least here in the US, Zoom. But we've had a lot of problems with Zoom, right? Zoom bombing, where people would broadcast pornography or obscenities. This has happened. And
yeah, Zoom actually created some problems here as well.
Is that right? See, this is the problem. When you have technology, you have to get used to all the challenges.
Well, and I guess it's one of those comments too, right? Of I don't think any of these platforms have had the kind of capacity that they've had now over COVID, and so I think they're learning in real time as well. And so, and not to belabor the point, but things like end-to-end encryption, well, obvious. I think for many of us, if we ever were to do a hearing in virtual, I think they were learning. What does that mean? How are there different servers situated across the world, able to handle it, the load that in COVID we put on it? How do you always ensure that there's protection and a password? These seem obvious, right? But I think we're all learning what is obvious to some may not be to others, and how do we ensure that we're talking the same language? I wanted to just make a quick point too, to Kabir's point of this idea of safe and good internet and the developing versus developed world. I think, it's also interesting to look at some of the key guidelines that have come out. And I'll name two as examples, but many list bandwidth realities. But both in the Seoul protocol coming out of the center in Korea, as well as the arbitration, the African Arbitration Academy, they specifically delineate bandwidth realities with this concern of, let's make sure that, in country or regionally, we understand what the parameters are. But the truth is we all need to do that. Even just yesterday, to be candid, when Kabir and I were testing, my internet, and I'm sheltering in place in Boston, was not working. And so, we all have these glitches, regardless of where we are. And so it's a reminder also that to not allow our unconscious or conscious bias to come into play in looking at how we can connect virtually, particularly for our ADR mechanisms, because at the end of the day, also technology sometimes just doesn't work. And so what do you do if that's a situation where you're going into a major hearing? What are the backups that you have? Because necessarily you have to have backups. If everyone has prepared and is ready to go, if one system doesn't work, what is the second system? Most of the protocols will always advise at least 2 systems in place, the second to backup, and even a third, just so that counsel and client time isn't wasted, and then we hit against that cost reality and that efficiency again.
Thank you, Rekha. That is so brilliant. And the final point actually I was going to mention is when we're doing things virtually, we need to make sure we're respecting due process for everybody involved, right? You want to make sure everybody's getting a right to be heard, everybody's getting an equal opportunity to present their case, right? We want to be strategic and thoughtful about these things. And Rekha, perhaps I can pass the floor back to you, because we have seen some due process challenge concerns being brought before courts, right? I'm actually going to thumb through to the next slide, but perhaps you can tell us what is happening in relation to cases involving Bolivia as an illustration for the due process concerns.
Right, so thank you so much, Kabir. We've taken a few cases as snapshots to talk about due process because it's difficult otherwise to concretize, although we're hearing a lot of due process objections coming out through COVID. And so we ask you sort of as a balancing test, consider each of these examples as that. Feel free to pause it in the chat or however you're comfortable, other concerns that you might have about due process. So we actually have an engaging dialogue, because I think in truth, these are things we're all thinking through, but unless applied to a particular set of facts, it becomes difficult. And same with examples or arguments of force majeure, which comes up in this case that I'm going to talk about in brief. So in this case, you may have heard about it. And And also, I guess, to underscore, the 4 examples we're going to give you are investor state examples, acknowledging that investor state arbitration is a carve-out niche within commercial arbitration. We focus on that because the record is public. And so to the degree you're curious and want to read on more, that you can access those documents on the different institutional portals by giving a Google to the case name or the case circumstances. And so it's for that alone that we give you these examples. And of course, there are a myriad of others. And so take this sampling and think through them with us. So in the case of this with Bolivia, it's a recent ISDS case. The Permanent Court of Arbitration, as we talk about institutions increasingly in this chat, they were administering and overseeing. And the case focuses on mining concessions under the US-Bolivia bilateral investment treaty. So Bolivia asks for an extension of time to be able to submit their statement of defense. And they cite to, of course, pandemic. The work has become virtually impossible. And they use arguments both of force majeure and frustration of purpose. They cite in general to global disruption. In country, Morales' resignation in November, but then they also talk about how other jurisdictions have been disrupted. They talk about the US's disruption in pandemic. The truth is that force majeure is a high standard. And so in reply, you see that claimant responds and argues that Bolivia failed to prove that the spread of COVID-19 was unforeseeable. And this idea of filing written submissions, it can be feasible, we can achieve this. And so it comes back to this advocacy reality when we're trying to counter arguments and argue with zealous advocacy for our clients, how do we do it? What is the best way? And so we also have to think about, the tribunal, when they came back and they considered it, they didn't accept a force majeure argument because of how high the standard is for force majeure. And so in pandemic, when we argue these concepts, how do we do it? How do we anchor it to the facts? And, one tribunal may accept a force majeure argument where another may not. But to think about as well, we are people operating in pandemic. And so in parallel with our professional lives, we're also wearing the hats of, other roles we play in our families, with our families with us. And so what does that mean? And sometimes the human element of just being able to argue that it's too difficult to be able to submit these pleadings because the counsel team is spread out all over the world, because they are also wearing the hats of mother, father, aunt, uncle, overseer of little children. And it's very difficult to produce such filings while in pandemic in light of these disruptions, right? We talk about
as concerns and how we see tribunals responding. Now, it remains to be seen if Bolivia will be able to challenge the ultimate award. We don't know. So that, stay tuned, as they say, to see how it develops. But Rekha, maybe we want to spend some time also looking at how the pandemic itself is giving rise to different cases, right? Because we're seeing that happening. Maybe we look at some of the examples of cases that are being threatened, how institutions might respond to them, and what the future might hold. Maybe we start off by looking at an example here of what's happening in Peru.
Sure. So in Peru, we're talking now about state measures. And so what are jurisdictions doing in pandemic, in emergency, to try to protect their own, as the argument may go for them from a nationalistic perspective, right? So in Peru, emergency measures have included suspending collection of toll fees. That began in the first week of April. And so this is problematic because there's a diversity of concessionaires, those who are running the toll booths across Peru. So just to give a brief breakdown to sort of anchor this aspect in your head, 24 are run by state-owned entities. 32 agreed to stop voluntarily when Peru said there's sort of a halting in light of emergency proceedings. And then we have 18 operators that are on the fringe, right? That are, they've seen this unilateral change by government saying tolls are being stopped, we're not collecting fees, you're just gonna let people pass. And so what does that mean, right? They've had a unilateral change in their contract to which that they haven't consented to. And it's been done in a time of crisis or emergency state. What will be the relevance there? And so it's this idea of layers of states of emergency, right? Too, in truth, in the example of Peru. So we have the state of emergency where it's a health emergency. And then it turns into also a national emergency. So what does that mean in terms of state powers and access to stop things? But then the larger question becomes, okay, it's one thing that the state has stopped collecting payment tolls, right? But how long will that endure? And particularly for those 18 outliers that didn't consent to the unilateral change in their contract, and that are just waiting, right? Because this has been their investment in, want a return on. And in truth, as we look at jurisdictions and examples, this is not necessarily a new thing for Peru. Peru has faced other claims from Spanish investors along this Pan-American highway about these tolls. It's really this idea of how do we deal with scales of impact, right? States of emergency. So in Peru, they went on a recent health study, 4,300 confirmed cases of coronavirus and over 100 deaths. I think we're getting some interference on the line. Maybe we can ask someone to mute the line. Maybe we'll just pause for a moment and allow.
Rekha, you carry on.
Okay. Okay, so it's really just that this idea of impact and death happening in a country and how a country is dealing with it, juxtaposed against this reality of what does a state of emergency mean? Is it within state powers? What will future states be? With that, can I turn it back to you?
Sure. Thank you. Hi, forgive me. I think there's somebody who's not muted. Maybe kindly request everyone to be muted. Thank you.
Yeah, sorry for that. Maybe.
No worries.
All right.
No worries at all. This is the reality of doing things virtually, right?
Yeah.
So I think you gave us the example of Peru, and I'll just give us pretty quickly the example the this is in response to the pandemic or whether this was a policy that they were mulling in any case. But it has happened in light of the pandemic, and they're using the reduction in demand as a basis to justify the action. And you're seeing an arbitration being brought potentially over this change in government policy. This is again another example where you're seeing a state measure being challenged in response to potentially an action taken during the pandemic. So we're seeing it in Peru, we're seeing it in Mexico. It's interesting that all the examples we have looked at so far are in Latin America, but this is not exclusively a Latin American problem. These realities probably extend to each of our countries, right? Each of our governments are taking measures, and we are seeing potential impacts on business. How businesses respond remains to be seen. With that, Rekha, we're seeing some fairly severe actions being called for. Justifiably, unjustifiably, we leave that as an open question, but we're seeing some measures, and perhaps you want to tell us a little bit about some of these measures. What is being put forward? What does it mean for us?
Sure. So thanks so much, Kabir. And again, we want to underscore, we did take snapshots. It so happened that they were in Latin America, but these are global realities of how will state entities deal with states of emergency and be held to task as things settle for the enduring reality of those states of emergency. So we're also seeing then, in light of court closures, in light of just backlog, institutions and organizations calling for a sort of moratorium on investor-state dispute resolution matters and new filings. We're seeing it particular in ISDS, and so we use that in context because the 4 snapshots of countries we gave you was also within the ISDS realm. But in general, to groups that are really calling for a halt in practice because things are so backed up, so that we can get to best practices without being overburdened. You know, it's really questions that we pose to you. Will it work? Is it the best way to handle things in the current state? Because we're still very much in pandemic. I'm cautious that if we emerge from it too quickly, that we can very, very readily go back to the emergent states we were in. And so we just don't know. We're seeing a lot of different dialogue. The truth is that if your client requests that things be filed, they want to know when it is done, and they want that deadline. We also have tolling deadlines, right, in order to meet with certain elements, both under institutional rules and also under, depending on where the seat of the arbitration is, under those rules and the applicable law rules. So are we always in accordance with all of that in having to file or not file? But we pause it more so for consideration and further dialogue. Will it work? And if there really is a call or a moratorium on filings, how long will it last? How long can we have really a moratorium on filings where there are many, many cases building up as we speak, and they're soon to be filed? Kabir, with that, I'll turn it back to you to take us a bit into our next topics.
Sure. I mean, we're seeing that the moratorium is based on 3 reasons. You know, this is what NGOs, bodies that are looking at realities are trying to propose. And they're giving us 3 reasons. They're saying we don't want to have arbitrations, especially in the investor-state context. But as Rekha mentioned, it starts with investor-state and then bleeds into commercial. And one point they're saying is that you will have a large number of claims. I think we can all agree on that. Pandemic is changing our reality. But the second point that they're saying is that governments should be focused on health. And the minute you're making a government focus its attention on other things, you're not letting the government focus on health, which should be the priority. And the third point is that, you know, these awards in the investor-state context tend to be fairly large. Again, you know, their concern is budgets should be devoted to the well-being of people. And if you're taking it away from that reality, it's not going to be good for the well-being of people. Now, whether this is going to bleed into commercial remains to be seen. But it's an interesting development and something that we should, as a community, engage with. Rekha, now let's talk a little bit perhaps about online mediation and online arbitration, and what are some solutions that institutions can think about. Perhaps you want to walk us through some difficulties first that we see with online mediation, that again, we want institutions to be thinking about these, evolving their rules and policies. So do you want to take this away?
Yes, I would love to. Thank you so much, Kabir. One of the things Kabir and I even talk a lot about is, what does advocacy mean in virtual, right? So much of what we do is to be able to react in place location. And so that does well enough in that it shows that there's no tampering. That it would switch between speakers. So where a counsel asked a question, there would be a pause before you got to see the witness's response. And although that's not an issue now, that was a concern early on. Wait a minute, what is the reply? Why can't we see the witness? And so I think in general, this is something that we're all thinking about. I think institutions are thinking about it as well as they try to chart best practices. But it's certainly difficult. And I think this is why I posited early on when Kabir said, where are we headed with ODR for arbitral proceedings? It's that I imagine that although we're all very much resilient and adapting, and I've just been so impressed by stakeholders' innovation in this time, that I see more of a hybrid reality for hearings, hybrid virtual, being acceptable, because I think there is this reality that we want to get together and that we want to coalesce and have proceedings. But the other truth is, depending on how many languages that are going to be translated based on the parties and the counsel and everyone involved, you're really going to run into some administrative headaches if everything is virtual, because it is difficult to do more than one language in translation, even two languages. When we're getting beyond that, almost like a UN meeting, how do you really achieve that flexibility? There's only so much that you can push the system to expand in virtual before you run into some very big concerns. And so with that, we're thinking about it, and you're seeing a lot of advocacy sessions roll out. I think Delos might even be doing one of these advocacy sessions, but advocacy in virtual, how is it different? How do we get our point across? Where in person, we use other tactics. Are there certain things that are just the same when we talk about advocacy? And so those are sort of generally things that we're thinking about. As we posit specifically with mediation, I'll say ODR has allowed this truth of breakout rooms, right? And so that a mediator can section off clients to have discussions. And that's proven very helpful for ODR mediation. The issue that pushes against that is comfort with the system. And so there are still a lot of fears or worries about having a breakout session where you're talking confidentiality realities, where you're talking about things and you're making statements on, what is your sort of maximum that you're willing to settle at? What if that leaks? It's the same reality that I think tribunals are seeing when they have the option to break out into a confidential breakout room. But do they? Most often they're going, via email, they're going via WhatsApp or iMessage, depending on their preference. They're not doing it within the portal. And so how do we build trust in the portal if we've been guaranteed by the platform end-to-end encryption and other security mechanisms? How do we increase our trust in the system? Well, we've already placed trust in coming online and engaging in this way. But there's still some hurdles with that I would posit to you that institutions are thinking through with stakeholders and trying to figure out. And part of it is just access information. And so I'll just give a reminder here. There is so much information out there that if you have a question about how to run online mediations or online arbitrations, don't hesitate to reach out to either Kabir and I. We can help you find those resources. But there's just a lot of reading for us all to educate ourselves on to be up to speed. With that, Kabir, I'll turn it back to you to sort of take us through some more of these difficulties, both as we look at mediation and arbitration.
Thank you, Rekha. I'll talk a little bit about arbitration, and I think a lot of what you said would apply here as well. See, when we're talking about using ODR for arbitration, some things institutions might want to think about is how do we prevent concerns relating to coaching of witnesses, right? And some best practices just maybe things like, you want them to actually affirm that no one's present. You want to make sure that you're limiting the number of devices. You want affirmations to these things. It also requires us generally to coordinate efforts, right? You're going to have to do tests, but then you also have to think about documents that you're going to show the witness. How are you going to do that? Is it going to be hard copy? Is it going to be electronic? Are you going to put it on your screen? If you're going to put it on your screen, do you have sufficient infrastructure to do that? All this requires some coordination. It requires the institutions to be thinking, how can we make that a reality? One point we are told as the best practice for arbitration actually is something that in webinars we welcome. You don't want your chat function to be active at a hearing for a variety of reasons, but I think it's also, sometimes there can be inadvertent leaks. But you think I'm communicating with Rekha, but I broadcast something to everybody. So generally at hearings, we disable your chat function. And then do you want to have your hearing recorded? This is something we want to think about, right? If you're going to record it, where is it going to be stored? Where is your virtual hearing going to be stored? And how do you ensure that that is kept in a secure platform? These are, again, realities for us to think about as we embrace this new technological reality. So in the interest of time, Rekha, I'll pass the floor back to you. Perhaps you can talk about some tips that we may think about to make this online reality a success. What can bodies like CIADr become really forefront thinkers on online hearings?
And a credit both to CIADr in general as they're navigating this space, and to all the institutions, because we keep saying they're teaching us how to think about this process, but they're also there, I think, to help guide the proceedings. And that's important in terms of faith in a system, because we've asked people to shift from a system they knew, get together in person and have a hearing, to a virtual one, which is different. And so it's the institutions, I think, that have started to have the dialogues, select a platform. Several with a US connection or a European connection have been using Zoom. Others very much don't prefer Zoom and they use WebEx. Today we're using Webinar Jam. And so we as speakers are neutral to this. I think, frankly, the more that we get to use, the more we're intrigued by the different capabilities. But you have to use a platform. This is obvious, that you feel comfortable in. And part of that is, what are the different modalities and functionalities that you can have access to, and to know what they are, so that to the degree you need to use one, either you're able to use it or the institution that's administering is able to jump in and say, hey, maybe you want to take this into a private breakout session. hey, maybe it's a good time to take a break now. The tribunals have really, that I've seen and I've heard, have really been adept at acknowledging when there may be issues where it's time to take a quick break, 5-minute break, everyone sort it out and come back together. But scheduling as well has been a huge thing for tribunals to really keep on target. Understanding people can't sit for as long in virtual hearing as they could in person, to really craft the process so it adheres to digestible chunks with necessary breaks, but also that, if something comes up, that they're able to say, okay, here's what we're going to do to triage in that moment. But also and separately to really have a clear cadence of who's speaking first, who's speaking next. That works also for webinars with Kabir and I. We often will set that, because what ends up happening otherwise is you end up talking over somebody else, which in person we would never want to do. And it's the same truth in virtual. We don't want to do that. It's not polite, but it's also ineffective to get your point across if you both are vying to say something on a topic. And so I found it even more difficult in webinars where you have multiple speakers. How do you appropriately allow each one to share their insights? They're usually often all experts, but do it within a, again, digestible time limit. It's really tough. And so setting that order of speakers, who gets to speak, who responds to questions. And frankly, in virtual, we have so many different engagement points, right? Somebody could be chatting and responding to each of the questions. Somebody else is talking. And so to make sure you're utilizing all of those points of engagement with speakers to really bring an audience in, but to not get distracted because there are so many things that you could be clicking through, that you forget that you're also presenting live or you're in a hearing live. With that, Kabir, I'll turn it back to you, please.
Thank you, Rekha. So if you want to succeed in this online reality, a few points we would recommend. Point number 1, test your setup. That is something we did actually for this platform. We all logged in a little early. We made sure we sounded okay, we looked okay. I adjusted my mic, which initially was only showing my face and nothing beyond that. Seeing me like this is creepy, right? So you want to test it. We want to make sure we have a mute option except for the speaker, just so that avoids background noise. You probably don't realize this, but we have actually people who are giving us tech support right now. And you always want to have that. It's one of those realities when you're doing an online forum, you want to have the tech support. And you want to have backup options. Sometimes internet drops. I kept both my phones next to me. And the reality was, what if the internet drops for me? I can immediately log on another platform, right? We want to make sure that we're using this new reality to give access and to facilitate greater dialogue. Rekha and I are very, very thrilled to be able to do something like this with you. We're in different continents, but this is what makes arbitration special, right? We're able to connect with our sisters and brothers across the world, talking about arbitration, sharing ideas. And one idea we're also told is don't use virtual backgrounds. Now, I think Webinar Jam, I believe, doesn't let you do that. Zoom lets you do that. And we're told not to do that for security reasons. You can't see what's happening with the virtual background. Just some tips. Now, just looking at CIADr, a lot of these are already processes y'all are adopting. If you can adopt these to your hearing facilities, which I'm sure y'all are, it really does put you all at a global platform, at a global footing. And so we commend you on that. Rekha, let me pass it back to you. What does the future look like for ODR?
Sure. Cognizant of the time, I did want to underscore one element that was on the previous slide that takes us into our dialogue on the future, which was this idea of diversity in virtual, diversity in ADR. As we've all moved to virtual, and frankly, credit to everyone who's been able to do it, diversity still remains a key point of how do we give access and advocacy to people, to a myriad of voices that really make our system better. Where when we were in person, it used to be that you could see the whole counsel team, right? So you could, or the secretary to the tribunal, you could see everybody, and you could see how counsel teams were varied. It allowed people to platform, even if they were just helping as part of the process and not the key speaker on that issue. But now we're in virtual, where we're not seeing whole counsel teams, for example. How are we giving a platform to people as a networking reality? Because we're also not meeting in the same way, even for our networking purposes, for arbitrators to be able to get their brand out, to be able to meet people, to engage. And I think here again, as our focus was sort of institutions, I want to credit the institutions where many stakeholders said the institutions do not have diversified rosters. They went out and they tried to diversify, right? But now we're really in a collective action problem of appointment. And I think it's the same in virtual, right? We're still picking arbitrators, whether it's a party's own appointment of a party appointed arbitrator, or you go by a strike and rank list method. We're still not getting to that point of parity in a diversity sense, whether you look at gender alone, or you look at race, or you look at whatever parameter that you think appropriate. And so how do we increase that for the foreseeable future, when we're going to be in this reality, our new normal, before we get to our next normal, right? And so I just encourage you all, as we think about that, both in a regional sense, within Bangladesh, how are we going to do it? And then globally, how are we going to do it? And I say that because Kabir and I talk a lot about, in America, how are we going to do it, right? But then beyond that, because if we're really international in scope, if we're really doing what we love to do, which is cross-border disputes, where disputes work is only going to increase as more of the filings come up through impossibility of purpose, right? How are we going to really make our system be flexible to this issue that we've often talked about? We've responded now to economy and to time in having to go virtual. How are we going to respond to diversity? And I posit to you, it's all of our concerns to make the system better, but there's no cognizable one path. And so I think if we all keep it top of mind, we're going to make the system better. With that, in terms of what the future holds, the truth is, and I think we can all admit this, time will tell. I encourage you all to visit the preferred institutions beyond CIADr and in addition to it, to see what the institutions are putting out, because I think it paves the path for where we're headed, right? The different protocols that are coming out still to this day, new protocols all the time, are demonstrating what direction we may go in for the future. But also we're all learning, right? Each of these times as we go through best practices, we're figuring out better ways to do it, better systems to do it within, better ways for counsel teams to engage. And so I think as we all keep remaining astute to bring our, ever learning curiosities, even as we go virtual, we're going to make the system better. And that's really the focal point. We aim for best practices, and we all have a role to play in that. But Kabir, the future, it looks really bright once we get out of this tunnel of pandemic, but tell us, what do you foresee?
I fully agree with everything you said, Rekha. I'm probably going to repeat what you said less eloquently. But, this pandemic, with all the devastation that it has caused, may create some forums for us to think about the future in a better, holistic manner. And like you, I remain optimistic that we engage and try to make it better. So with that, I will move it to the minions to thank you all very much. We're very delighted to be here with you. Again, this is a reality which, few months ago would have been very difficult to think about. And so we really, really are very happy and thrilled to be with you.
And I think well, just to say, groups like CIADr, we think are so fantastic because in pandemic, it's also a curiosity in question. Will we become more regional in how we resolve disputes? And to that end, these burgeoning, all-star groups that are coming out like CIADr, to triage proceedings, to be in the front line, is really important, I think, as we look at jurisdictions and how we're going to engage collaboratively. So a credit to this group, with sincere thanks from Kabir and I for inviting us, because this is the start of an ongoing and everlasting relationship. So,
pleasure is ours. Thank you, Dr. Kabir and Rekha, for an insightful presentation. I'm pretty much convinced that our audience learned a lot as much as they enjoyed listening to you guys. So moving on to our next segment, that is question answering session. All the questions seems to be related to the basic of institutional ADR, since the whole concept of institutional ADR process is still novel in our country's perspective, and it's still developing. So the first question is actually mine, due to the privilege that me being the moderator today. The question is, we know that in institutional arbitration, the institution virtually acquires certain powers of the parties and are in a position to impose their will upon them. Doesn't it seem to be against the very spirit of arbitration?
Rekha, would you like to take it? Would you like me to take it? I probably pass it to you.
Maybe I'll start and then pass it back, I think, because I think here we'll go back and forth with maybe sort of institutional perspective against practitioner perspective, so we make sure we're in sync with where the truth may lie. You know, if you look at many of the arbitral institutional rules, they're often general in nature so that they have broad application. I think you'll find there are differences in terms of how different institutions administer processes, much of it working towards this idea of, is it a deep dive review of an arbitral award, or is it more an administrative oversight review? And I think that's how these processes build up. That's how we anchor them, depending on how ultimately they oversee an award and its issuance therewith. But you know, especially in this time of pandemic, institutions are very thoughtful. They don't want to step in the way because they understand that it is the tribunal that is overall running the process, that it is the tribunal, if not the tribunal and the institution's award that comes out. And they want the tribunal that was appointed to make determinations, because otherwise you enter a very difficult boundary of whose role is it anyway. And then when we get to enforcement issues, it's rare that you see institutions brought in, but will they be brought in increasingly? I would argue to say no, because in pandemic, they're leaving it to the tribunal to really decide. And true to form, any of these conversations, for example, where institutions are being asked, what is your take on due process, where a tribunal encourages parties to move forward even on objection of one of the parties, and the tribunal will say it is in the jurisdiction of the tribunal to make that determination. Our rules have always allowed for hearings to go virtual. It's just that they were never embraced before pandemic because we all elected to meet in person. So now as we take those general rules and we make them go live and make them use, what does it mean? But I think you'll be hard pressed to find institutions that take a hard line stance on saying it's our way or no other, especially because people go to them because of their adaptability and their versatility. But with that, I mean, Kabir, from a practitioner's perspective, and also serving as an arbitrator with many institutions, what are you finding?
I mean, I would agree with everything you've said, Rekha. You know, I think the role of an institution is to recommend things. They often do that in consultation with the parties, often also leaving the final prerogative to the tribunal and or the parties. So I think the process tends to be a collaborative one. When final decisions have to be made, it's often left to the, to the tribunal to give the stamp of authority under a tribunal's procedure. So I think the question is a good one. I think arbitration being a bespoke process and a flexible process has mechanisms to try and accommodate these different realities. So I'll stop here. Yeah, please, back to you.
Other thing I guess I would just add is, as we're having a conversation in general about institutional practices against tribunal practices, there are also these other realities which Kabir and I have often spoken about, and written about the soft law capabilities that can be brought into the purview of a proceeding. So now we're talking, for example, the IBA rules on evidence as against the Prague rules, very different approaches to activity of a tribunal. And, do they take the inquisitorial approach? And how do they do it? How do they manage a proceeding? And to me, those are also curious as we respond to your very thoughtful question, because it fills in the contours of what does control mean? In truth, it's always going to be a party-driven process, but where oversight is needed, how do we do that? And tribunals very much want it to be a collaborative process. I think you'll hear many echo that. But what does that mean as we jump between civil and common law systems? What does it mean to really be international and to move forward? What does it mean where a party is uncomfortable in virtual? Do you just delay until you meet in person or hybrid virtual? Do you move it forward, letting people know if by a date certain, if it's not safe to gather, then you definitely move to virtual? Because there's also this expediency, right, of a tribunal to come to a determination. That's why parties chose arbitration, to move the time clock forward without undue delay. What does due process mean against that context as well, where we're in constant states of emergency right now, out of safety, security, and human health? So we're really in an interesting state of play where there's not a salient one answer. But I think, everyone is very cognizant of, let's understand what the parties' read is on this. Let's listen to them. Let's even have them brief it. And then let's think about it. And in consultation with them, with the institutions, and with anyone else that matters towards that decision, we'll be thoughtful. But at the end of the day, we have to get our work done. And so how do we do that?
Okay, thank you for your detailed answer. Much appreciated. There's a question asked by Hugo Cardona. He asked, do you think that accepting force majeure on grounds of the COVID-19 would affect the whole international arbitration system as stated by the tribunal in the case of Bolivia?
Perhaps I'll just take a lead there.
Right.
I think the finding in that particular case relates really to the arguments put forward, the facts put forward. I think the argument in that particular case dealt with counsel in Paris and in DC, both of whom were in lockdown, and a political reality in Bolivia, right? They had a change in government.
Yes.
How far these are replicable, I think, will be a fact-driven process. It's hard to draw too many conclusions right now. It also depends, with time passing, how are we going to look at the pandemic? I think a consequence of COVID is we're suddenly realizing things that we thought may not have been possible. Even at the beginning of COVID, no one realized, the realities of how severe it was going to be. Whether that is going to create greater empathy, again, I posit that as a question for us to consider. It remains to be seen more generally how all these arguments are going to be perceived by tribunals. So I'll stop here, Rekha, and pass the floor to you to see any reactions you may have.
No, I think you said that really eloquently. I think the big difficulty with taking a snapshot of a force majeure example and expanding it to a larger dialogue on where we're headed in international arbitration is really problematic, because it's a very fact-driven analysis. And that's why if you look at many of the webinars about force majeure, they're really general. They more so take on the wave of like a law school course. We talk about the law, because it's really difficult to apply it to a case, because every single case is different. And that perhaps is this idea of, okay, well, that doesn't satiate me towards my question, and we really appreciate you positing it. But it's the unfortunate truth, and frankly, the reason why we are all in business and disputes, because we get to apply the very general doctrine to the specific examples. The other, I think, thing I would add to this is, as we look at foreseeability, which is a major element of force majeure, the longer we stay in pandemic without a time certain, I think many of us are looking for right now, a deadline. We're used to operating our lives on deadlines. Just give me a deadline when COVID will be over. Give me a deadline that I can work towards, because I understand deadlines mentally. I can do it. But without a date certain, where does that leave us with, all of the different things that are unfolding? And that makes it really difficult too. Do things become more foreseeable the longer we stay in this? And I would even say to you, I would reference back to past pandemics, like the 1918 pandemic. And, where pandemic is not a new thing to us globally, although it has been a while, what have we learned from the past? Well, one could argue we should have known that it would ricochet and affect our whole system globally and put us down. And I would encourage us to think along those lines, regardless of which side we represent, because it's a difficult argument and a high standard, but certain cases will meet it and others won't, and certain tribunals will accept the logical reasoning behind it and others won't. It will really just depend. And we don't have a lot of cases to show as examples as the other thing, but we would be remiss if we didn't give you an example where a force majeure argument was made and what the outcome was in that case.
All right. Thank you, Rekha, for your answer. I believe, Hugo, you got your answer right now. So the next question is asked by Biva Mosharraf. She asked, in institutional arbitration, parties need to comply with the procedural requirements, resulting in unnecessary delay in the arbitration. What's your opinion to it?
So maybe I'll take this first, Kabir, just from an institutional. So, the procedural guidelines set very specific, in some instances, under certain rules, parameters. Usually it's with regards to issuance of an award, also submission of the initial pleading documents, the answer, and then the back and forth submissions therewith, right? So there are crafted sort of timelines, but they're not hard and fast timelines, right? This is again arbitration, where agreement is really the cornerstone of it. And so the truth of the matter is, I think it will be curious to see increasingly in cases, are counsel in agreement? Usually we're counsel in agreement and they posit a timetable that may be modified against the procedural rules to the tribunal. The tribunal will consider that and really think about if there's any reason to modify that proposed timeline where the parties are in agreement, and it may be very few things they agree on. But if it's timeline, why go against that? Unless, let's say, the deadlines are like, we're going to wait for 3 years and push this out, intensively. But we're not really seeing that. I think for dispute lawyers in general, that there's a lot of work to come, and so you don't want to push out the timelines without knowing what will come in, down the road. To that end, though, I do think institutions can step in, and some more than others, without being specific to them. It's really, in overseeing the process, I do think institutions have this artful line that they have to walk. They have to walk it to oversee. They have to be there as needed to help police the parties and move things along. But it's within the parameter of, you have this, erudite group of leaders that the parties have selected to run their case. And in no way does the institution want to get involved to disrupt that relationship if it's working well. But if it's not, I always say this, to having been on the institutional side, where a counsel team feels like things are running slower or not apropos to the given schedule, it is totally in their prerogative to either raise it with the tribunal, or if they feel uncomfortable doing that, to raise it with your case counsel. That case counsel can either be your assister neutrally, that they can, be the ones that are a clearinghouse for comments and concerns, and then figure out how to share it best with the tribunal to move things forward. And so use the institution to your advantage to share concerns, to share curiosities, and especially, if not during the proceedings for any reason, after the fact, to share those comments. We only get better if those comments are able to be digested and then understood and figured out how to be inserted to make the process better. But Kabir, with that, as a practitioner and deadlines, how do you find that? And also as an arbitrator, modulating.
I fully agree with everything you've said, Rekha. I think this is a process the parties will engage with one another. Yes, you do have guidelines that are given, but parties will try to come to a consensus. And as you said, this may be the one thing that they will likely agree on. So just to echo what you have said in a less eloquent manner. Folks, I'm going to have to leave off very soon. I just wanted to share this. Forgive me, I had my next call in another 5 minutes.
All right, yeah, I get it. Just another question. I'm just going to wrap up in just 5 or 10 minutes. Is it all right with you?
I may drop off, but I will let Rekha definitely carry on here. Is that okay?
Oh, yeah, sure.
And we can even, it may be apropos at this point to say, let's take one more question quickly. And then any other questions, please feel free to share them with us, with perhaps the person who asked it. And we'd be happy to think and respond so we continue the dialogue online.
Oh, all right, thank you. So the last question is, which ensures more fairness in commercial disputes, institutional arbitration or mediation? Like, which one do you prefer? Is there any set of rules for picking one? This is asked by Zahir Raihan Khan.
So this is a tough question. And I guess I'll say many of the institutional rules, be it for mediation or arbitration, converge. And so maybe what I'll do is, in light of the time, Kabir, do you want to take this first as a practitioner? And then I'll take it back from the institutional perspective and we'll close out.
I don't know if I have a very good, a very clearly thought out answer here. Rick, probably you can talk and I'll react to what you're saying.
Well, I think the biggest thing I was going to say is, we're seeing a convergence of institutional rules overall. Yeah. Many of them echo similar realities. I think the big differences are, and this is something that anybody needs to zero in on, is the manner in which a tribunal is appointed. Institutions differ on that. They differ on the amount in controversy and how that amount affects payout to a tribunal. And they differ in review of an award. So these as 3 concrete items, and there are more, are important to look at. If you have a very specific process and vision, there is an institution out there that matches that. But be cognizant of these different ways: appointment, and review, most importantly, of the arbitral award, because that then goes, it acts alongside, let's say, time and cost parameters. But beyond that, it's really difficult to say. The 3 things I'm really impressed that institutions overall have adapted into their rules, which I've mentioned already: expedited arbitration, emergency, and interim relief. All 3 of those elements we haven't always seen before. And so I think that's hugely important. We're also starting to see bifurcation and consolidation in commercial proceedings. It used to often exist in construction, but we didn't talk about it as much in commercial, and especially now in pandemic, I think hugely important. How are we talking about consolidation? But with that, I think take a look at the rules because they're often similar. It's the processes the institutions offers, and it may be contingent also on the jurisdiction in which they sit, where their headquarters are, in terms of what the preferred practice is. But there's really a diversity of certain things, but not of others, and it just depends what's top of mind for your client. Oh, but please make sure whatever institution you pick, that you actually, if you're putting it in your arbitration clause, you delineate. I know this sounds obvious, but the right one, and at the 11th hour, to not create a pathological clause. A very simple example of that is, I want to apply the ICC rules, but have the ICDR administer. They're just two different and lead institutions. That's not going to be workable. So what is the best way to do that? To really think about it. Pick an institution and delineate their name exactly, and see what you think works best.
All right. Thank you, Dr. Kabir and Rekha. Since we are running short of time, we're going to wrap up. All the remaining questions will be mailed to you. Is it all right if you answer those at your convenient time?
We will.
Thank you.
All right, thank you so much, Rekha Rangachari and Dr. Kabir Duggal, for your didactic speech and the question answer session. It's been much pleasure to have listened to your fruitful discussions. Institutional ADR plays an indispensable role when we talk about out-of-court settlements, and is the requirement of the brave new world, and the enlightenment by our keynote speakers on this much coveted topic surely benefited us all. Only a better comprehension from today's discussion can render this effort as a success. It was a precious experience for us to take part in this discussion in a candid manner with our new friends here. I sincerely hope that this new friendship will last a long time. Thank you to our keynote speakers once again for taking time out of their busy duties to attend and address this webinar. I would like to express my gratitude to CIADr and NYIAC for such a wonderful opportunity to have arranged this webinar for younger and upcoming lawyers like us. These kinds of opportunities are much appreciated and beneficial for our professional enrichment, which will help us in the long way. With this, I would like to close my remarks and bring down the curtain on today's webinar, wishing the future prosperity of our honorable speakers here and all the participants. We appreciate you being here. Thanks for joining us today, and we will see you next time. Stay tuned and don't miss out on our next episode. Farewell. Stay safe, stay home. Thank you.
Thank you very much. Thank you.
Thank
Bye.
you. Bye.
Pleasure of mine. Goodbye.